are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time to talk about all matters relating to estate planning and trust and estate administration, both from the standpoint of you doing your own personal work in that area and also for professionals like my guest and me who help people with estate planning and administrative issues. And so I don't want to take a lot of time to introduce the show. I want to get right to my guest, Kelley Way. And Kelley is an estate planning attorney, but also an intellectual property attorney. And so having expertise in both those areas of the law really puts her in she's the only attorney I've met who is involved in both areas. So it really puts her in a unique position with respect to estate planning for this area of property, which, in our content drenched world, I think is so important and will become ever more important. So Kelley, first of all, thanks for coming on the show. Welcome.
Well, thank you so much for inviting me. I'm glad to be here.
Yeah. So with all of my guests, I don't want to do a whole big elaborate biography of them. I'd rather, sort of tell us a little bit about your background, how you came to have this, like I said, I think really unique combination of legal skills.
Yeah, so I decided I wanted to be a lawyer back when I was a teenager. And back then, what was important to me was I loved books and music. So I knew I wanted to do something that involved one or both of those. And I did not want to be self-employed, which just shows that life is full of irony. But that was one of my big criteria back then.
Uh-huh.
And so I thought as a lawyer, I could be working with artists and authors and musicians. So I'd be in that world, but I'd be working for a firm. So I wouldn't be self-employed and I could get a good paycheck to boot. So it all sounded great and it was all wonderful, until I graduated in 2010 and there were no jobs because we were in a recession.
Right.
So it's a bit of a long story how I got to be solo practice, but basically that's what ended up happening is I'm a solo practice lawyer. And in order to expand my client base, I decided to add estate planning onto my practice areas. And now that's the bulk of what I do, but I still have the most fun with the copyright and trademark work.
I can imagine. So talk to us, if you would, about what you see as perhaps let's say the 3 or 4 most important considerations that either people who have intellectual property or lawyers who are working with clients who have it need to consider when they approach, this aspect of their estate planning.
So when they're doing the planning side, really what it comes down to is who's getting the intellectual property, who's going to manage the intellectual property, where's it all going to go? If you're just like, I published one book and I make $5 a year, then, you don't really need to think very hard about it. You can just say that, yeah, the copyright goes to this person, they can do with it whatever they want. But if you have published a whole series, it's making good money, you got a lot of income coming in on it on a regular basis, then that's something where you really want to give it some more thought because you want it to keep making money. And so you need to really think about who's the best person that can keep that money coming in, who can continue to market the book. And do I want that to also be the person getting the income? Or do I want the income to be going to some other person and that person's just the manager? So a lot more moving parts when you have a lot of income coming in and things to consider. But that's really what it boils down to is who do I want to benefit from it and who do I want to manage it?
And maybe I should have asked this question first. So define for us, if you will, intellectual property and give
Mhm.
us, examples of it so people understand, because it really goes beyond books and music these days, I think,
Mhm.
right?
Yeah, it does. So intellectual property, it's an umbrella term. It refers to any kind of property that has value. You can buy it, you can sell it, but it's not a physical thing that you can reach out and you can touch. That's why it's called intellectual property. It's property of the mind. And there's a bunch of different categories. The three main ones that most people are aware of when it comes to intellectual property would be copyrights. That's your books, your music, your movies, your creative works.
Okay.
Then you have trademarks. That's more for the business people. That's your branding, how you identify yourself in the marketplace so that consumers know who they're buying from.
Hmm.
And then you have patents. That's the science side, inventions, formulas, processes, things that are patented at the US Patent and Trademark Office. Those three tend to be the most common forms of IP and the ones that you most typically are going to want to think about when you're doing your estate planning is, are they still going to be around? Are they still going to be making money? And how can I make sure they keep making money?
Okay, and so taking those three categories of intellectual property, uh,
Hmm.
what what are the ways that they typically generate some kind of value then that has to be understood and I guess analyzed to see if it really needs to be part of an estate plan, if there really is any value there. Like I'll give you an example. This has been a lot of years ago. I used to get this publication, and it was focused only on valuing brands, and
Hmm.
each quarter, I think it would give the value of the most valuable brands in the world. It was usually like Coca-Cola, and these, it was astonishing the value of the Coca-Cola brand. Even back then, it
Hmm.
was,
Hmm.
billions and billions and billions of dollars. And that was my kind of my introduction I was an appraiser at the time. That was my introduction to the value. So I could, like in a company like Coca-Cola, I could see where, wow, yeah, there's a tremendous amount of value there. For a company like mine, I mean, I do my best to brand right, but I'm skeptical that I built any value there. So talk to us, if you would, about kind of the value issues that relate to each category, and how those need to be maybe analyzed and dealt with.
Yeah, so like you said, all of them have a value, and when you're administering an estate, you have to come up with the date of death value for everything, which would include the intellectual property, because those are assets that are subject to probate if you
Mhm.
don't put them in a trust. And so you do have to come up with a value for them to see if the estate is over the probate threshold or not. And there's different ways to go about putting a value to it. Like with a patent that hasn't actually been used yet, for example, probably the most typical way that would be done is what would be the cost of recreating the invention.
Mm.
And that would be the most likely way to describe and get a value for a patent that hasn't actually been put to the market yet.
Mhm.
Whereas with a copyright, like a book, you might do like you do with real estate, where you look at comparable sales and do a value based on some similar things that have sold recently and what they sold for,
Mhm.
which is great when you can do that. But with things like copyrights, that one can be tough just because what really is a comparable asset.
Right. Right.
So, it's great when it works, but finding something that's truly comparable can be really difficult. The other one that's probably the most common, it involves more math, but essentially coming up with a projection of predicted future earnings.
Mhm.
And so, yeah, and that one, like I said, you're making a prediction, but what do you think is likely to be the future income stream from this asset? And that's probably the one that's the most commonly used, is figuring out that future income stream to determine a present day value.
So interestingly enough, I was working on just such an analysis before the show started. In this case, it wasn't for intellectual property; it was for a billboard owned by a billboard that's on a property that's owned by an estate, right? And
Mhm.
someone has come along and said they want to buy not really the billboard; they want to buy, I guess, the rights to lease out the billboard. They want to buy us out of our lease, in essence. And the
Mhm.
question is, which is better, to continue to get the rental from the billboard company, or to take the buyout and have the cash up front. So I'm doing
Mhm.
a discounted cash flow analysis. I will say that Chat GPT makes that a lot easier
I bet.
than when I used to have to do this by hand, because I can just prompt my assistant for formulas to plug into Excel and all that. Okay, so we've got comparable. We can look at comparable sales, in essence, of some kind of intellectual property, or we can look at some sort of present value based on a projected income stream, right? And I mean, is this the kind of thing, as an attorney who advises people on this, will you do this kind of work, or how do you, I guess, facilitate helping the client figure out whether they have valuable IP that then needs to be addressed in an estate plan?
Mm, I'm not one of those people that enjoys doing math, so you're not going to see me crunching the numbers. I'm more likely going to be saying, well, how much is it make? How much is it making now? How much is it likely to make in the future?
Hmm.
And use that as a gauge for how complicated a plan we want to be putting together right now.
Hmm.
Most of the time, when I get looped in, the things that I'm figuring out are, like I said, who is it going to go to? Who is going to manage it? And is that going to be the same person? And that tends to be the most frequent thing that I'm helping them to figure out is how do we incorporate this into the estate plan so that, yeah, the money goes where we want and it continues to actually make that money.
And you mentioned there's kind of two parts to that. There's the sort of manager, maybe the rights manager, whatever we'd call that person, and then the
Hmm.
person who's going to actually collect the money. It could be the same person, but it may be two different ones. So how do you work with your clients to determine, who is going to fill those roles?
So again, it's a conversation. So if we're talking somebody, the $5 a year person, you might as well just give it outright to the person you want to collect the proceeds. They're not going to do much with it, most likely, but it's not making much money anyway, so it's
Hmm.
not a big deal. When you're talking again, I'm getting regular income. My entire living is on these book sales.
Hmm.
Then that's a point where it's like, okay, so first, who do you want to get the money? And second, is that person somebody who can manage it and do all the marketing and everything else that you're doing to make these sales keep happening? Are they good for both of those things, or are they not a good manager and you need somebody else to do the managing while they get the income and the benefit?
And assuming that the recipient of the money is not a good manager, or maybe it's, they want their children to get it, so their children aren't even
Mhm.
old enough to manage it. So
Mhm.
what do you do in that case?
So, in that case where the beneficiary is not a good manager, then it's, who in your life would be someone who can manage it well. And oftentimes, people who are making good money, they have an agent or a manager or something along those lines already. So,
Mhm.
most of the time, it's simply authorizing that person to continue managing after their death. And so oftentimes, if it's making good money, they already have someone like that in their life that they can appoint. And if they don't, then yeah, it's who do you trust? Do you want to hire a professional? Do you want to go out and interview people? Or is there someone that you feel would do a good job and can do all the things that you're doing and, keep that money going?
Okay. So it occurs to me that, so I have a friend. He's written a series of books.
Mm-hmm.
They're actually detective novels,
Mm-hmm.
and he and his wife, they live off the proceeds, right? Uh, Look, at some point, he's going to pass away, Presumably it's going to go to, you know, whatever money it's still generating is going to go to his wife. But at that point, once he's gone, there probably isn't going to be any more intellectual property created, one would assume.
Mm-hmm.
Or is you know, do you take into account, well, you know, one that leaps to mind for me is, um, shoot, trying to think of the author. One of the authors I used to read, oh, I know who it was, Dick Francis. He wrote a
Mm-hmm.
series of books, detective books. They're all set in England against horse racing. Loved his books. When he died, his son took over writing the books. They actually wrote a couple together toward the end of his
Mm-hmm.
life, and then his son took it over, right? So, um, how do you deal with the potential continuation of the development of the IP, which strikes me as being a different issue from merely what we might call the exploitation of the existing IP?
Mm-hmm. Yeah, you're right. That is a separate issue. And, the general rule is whoever owns the copyright can make whatever additional derivative works they want to make. So, it could just be as simple as that, where you give the copyright and the copyright owner, if they want to keep writing more novels or making more works, can do so. Or the other option is, so, for example, maybe you want it to stay in trust and your trustee is your manager. And you can specifically say in the trust whether they're allowed to continue making derivative works or whether, once I'm gone, it's done. And,
Mhm.
different people want to do things different ways. Some people, like you said, they want to see their legacy keep going and they'd love other authors to come in and pick up the reins. And other people are, no, it's mine. Once I'm gone, it's done.
Right, right.
So, yeah, if that doesn't matter to you, you don't have to say anything and it's up to the new copyright owner. But if it does, you want to make sure to say something.
So I'm reminded of, I think, one of the best known cases, which is, you know, James Bond, right,
Hmm.
where Cubby Broccoli's, I think, son and daughter took it over, and they made it. They, you know, originally the deal was with United Artists, and there's been a big thing now. I think it is with Amazon. I think I read sometime in the last couple of weeks it's been resolved, but there's, in this case, it seems like it was unclear who really had the authority to make decisions about the ongoing you know, works that the derivative works that could be made, you know,
Hmm.
of the copyright. So, you know, in this case, we're talking probably billions of dollars. That's not where most of us are going to be playing this game, but it does show you the stakes can be extremely high, and as can
Hmm.
the costs to work them out. So.
Yeah, yeah, and that is another issue that can come up. But when I get brought in on the administration side, that's the most frequent question is, well, what happened to the copyrights? Who owns it? What rights do people have? Frequently, we have people like, oh, that he has a manuscript, but it never got published. I want to publish it, or something along those lines. And it's a question of, well, I need to see the documents. The first thing that has to get answered is who owns the rights. And
Mhm.
then, I can tell you what you can do once I know what happened to it.
Right, right. Good. I'm going to take a break here just a minute to remind our viewers. This is Trust and Estates Weekly. We're here every Monday at 10 a.m. Pacific time. My guest is Kelley Way, who is an estate planning attorney, but also an intellectual property attorney. And we're talking about estate planning and intellectual property. Today's show is sponsored by Probate and Trust TV. This is a new YouTube channel that aggregates all the best content on estate planning and probate and trust administration. So if you, especially if you're a professional and you're looking to get questions answered on a whole range of subjects, from various types of trusts, complex issues, legal, accounting, tax issues, Probate and Trust TV brings that all together for you in one spot. So I encourage you to go to YouTube forward slash youtube.com forward slash at Probate Trust TV and check it out. And if there is a content provider that you do not see there, that whose content you like, let me know, and I'll be happy to investigate that and see if we can include their work in this channel. So thanks to Probate and Trust TV for sponsoring today's show. And by the way, there will be a link to it in the show notes after this episode posts on YouTube. So going back now to our topic of estate planning with intellectual property. So, Kelley, what happens if the owner of some IP dies intestate? So they didn't leave a will. There was no trust, right? And here's this, and let's take a case where the intellectual property actually has some real value, right? What's going to happen in terms of the income stream from that IP, but also in terms of ownership of the copyrights, or ownership of the patents, or the trademarks? What's going to happen with that?
So as far as the management, whoever it is that steps forward to be the personal representative to be in charge of the estate until the probate is closed, they're going to be the one who's in charge of managing it. And, this is a reason why if you're making money, you want to plan these things in advance, because pretty good odds if you died intestate, whoever it is that's stepping in doesn't have the foggiest idea what to do with your IP. And so what's probably going to happen in that case is that it's going to languish. It's just going to sit there gathering dust and becoming less and less relevant while they work through the probate process, because the person, maybe they know about it and maybe they don't, but most likely they won't know what to do with it. And then once everything is finally all said and done, it's going to be divided among your heirs. Unless there's somebody who's, raising their hand and saying, me, I want the copyrights, that or whatever the IP is, then everybody's going to be equal co-owners of it, because that's the way it normally works. And I don't know about you, but having a whole chunk of people that are co-owners of something, money managing thing like IP, just does not sound like it's going to work very well. I haven't checked up on the Prince estate recently, so I'm not quite sure where that one landed, but 6 siblings being co-owners. And last I heard, you had 3 of them put their assets into an LLC and 3 of them put their assets into an LLC. And I guess the 2 LLCs are working with each other. I'm not quite sure, but to me, it just sounds like a whole lot of hassle.
Yeah, I mean, I haven't handled an estate with significant IP in it, at least not yet. Although I frankly would love to have the opportunity, because I've been involved with IP since I was a law clerk, going back into the early mid 1980s, and so the subject has always engaged me. But the idea of having multiple, not so much multiple owners of a copyright, but multiple people have a say as to what's going to happen with it, strikes me as being a good way to basically destroy the value of that copyright. 3 people, 5 opinions kind of thing.
Yeah, exactly. If they don't work together well, if they can't make decisions together, or if they just have different ideas about how this is supposed to get done, it's just going to be a nightmare, because they're going to be stepping all over each other and fighting with each other. And in the meantime, the IP is going to suffer.
So taking kind of the kind of IP we've sort of been talking about, I think, is more like copyrights. But taking another example, let's take a trademark example. Let's say that there was, the estate includes a business, and for however it happened, the business has a trademark that is a significant asset of the business. So, again, let's take kind of the same situation though. You've got an estate. You've got someone who's died intestate, but one of the assets is this company which owns this trademark of significant value. So, what are the issues there that people need to be aware of, either to avoid such a situation or to deal with it once it's been dropped in their labs?
Yeah, with trademarks, that can be a little bit trickier because that's business. And then you run into the question of how is the business held? Is it a sole proprietorship? Is it incorporated? Is it LLC versus S Corp? And all those other questions. And, again, was the trademark owned by the business or is it owned by the person?
Hmm.
So that's another layer of complexity to figure out when you're dealing with a trademark in an estate. Let's assume that it's a sole proprietorship.
Hmm.
So not incorporated, and they have a trademark, and they did pretty well as a sole prop, and even though they never incorporated, but still doing well overall. And they die intestate, and then the business is going to be an asset, and the trademark is going to be an asset. And once again, generally speaking, things get split every which way, divided equally, unless there's somebody that specifically wants that. And with the business, again, you also have the complexity of who's qualified to run the business. Is this something that just anybody can step in and take over, or is this something where you need specialized credentials in order to, be allowed to run the business?
Hmm.
And with businesses, I think it's more likely to happen that the business is just going to get liquidated and the whole thing is going to get sold unless you can find somebody among the beneficiaries who wants to take it on and is qualified to do so.
Hmm. And you brought up something that I hadn't thought of that seems to me even potentially more fraught, and that is, let's say you have a situation where the business is a corporation, whether it's an S or a C corp, doesn't matter, but for whatever reason, the trademark was owned outside the business. What comes to mind is Walt Disney Productions,
Mm-hmm.
where Walt Disney's family, through a sort of a family-owned business called Retlaw, owned, among other things, the name Walt Disney with the sort of the way that it was, calligraphy,
Mm-hmm.
whatever it is,
Mm-hmm.
right? And Walt Disney Productions, the company that was exploiting it, didn't own it, and so now you have this splitting. So how could that impact the value of the business if if those two are separate? It seems to me that there could be a possibly large diminution in the value of the business if the copyright doesn't get sold with it, or doesn't is can't the business can't compel its ability to use the copyright, or I mean not the copyright, I'm sorry, that it can't be compelled, uh you know can't compel its ability to use the trademark, I guess is what I'm saying.
Yeah, I would agree that that would impact the value of the business if the name that it's operating under is actually owned by another entity and they have a license that can be rescinded at the whim of the actual owner. Yeah, that would definitely have a impact on its value because they could be forced to rebrand at any time, and then that would be a massive blow because they'd have to spend a lot of time and money in order to rebrand and educate the public on their new name. So, yeah, if someone does incorporate, then ideally that corporation should be the owner of the trademark, which also makes things easier if there was going to be a probate because the business itself, a corporation is its own entity. So the entity is not subject to probate. However, your ownership interest, that part is part of your estate. So the ownership interest is going to be subject to probate, but the business itself, particularly if it's a multi-person business, multiple people go, and it can continue to operate and run as normal while they're figuring out where that person's ownership share goes.
Mm-hmm. And you mentioned if the business has a license to use the trademark, uh, what happens with that license? Let's say that when the decedent dies, the license, at least a term, according to the terms of the document, says, okay, it has another 5 years to run. What
Mhm.
happens to that license as a result of, the administration of that estate?
So a license is basically a contract. So it really comes down to what the terms are. So if the contract says you have the license, you have permission for the company to use this trademark until I die, and once I die, then you have 5 years before you are no longer allowed to use this license. Then that gives them a heads up that it's time for them to start working now on a new platform and new branding, or go back to the executor or whoever's in charge of the estate and see if you can work out a new license. And if you can get them to sign a new license, then that's great and dandy, and that's wonderful. But if they say no, the contract's the contract, and we're sticking to it, then yeah, you have 5 years to get your act together and figure out a new brand and start switching over.
Okay. And from the presumably, if again, this is a situation where the trademark is owned outside the business, right? That's why there's a
Mhm.
license agreement. So now the heirs to the estate, they're going to become, in essence, the licensor. No, they're going to become, yeah, the licensor, right? The people who are giving the license. Um,
Well, while it's in probate or while it's being administered, the executor would be the licensor. It's not until it's actually been distributed that the beneficiaries would become the licensor.
right, right. So the executor, right, the executor, and then the beneficiaries of the estate. That's kind of the chain of the licensor. If the company decides to rebrand, what then? How would that impact? Do you think the value of that trademark?
Uh, Yeah, that's why you got to be careful with these licensing agreements. Because if we go back to the Walt Disney example, Walt Disney is very much tied to the corporation. I really don't know what they would do with that trademark if they decided to not let the corporation use it anymore. And I don't know how much value it would have if they no longer tied it to the company and decided to use it on something different. I think that would, in many circumstances, be an unwise move on the part of the trademark owners. But again, it really depends a lot on the circumstances and whether they think that they could do something with that brand that's better than what the current arrangement is.
Right. So I guess if their thinking was, well, we can start another Disney company, maybe that'll do, better. I mean, I think if, as I recall, at one time, going back to the James Bond example, there were actually two James Bond tracts, one being followed by Cubby Broccoli's children, and another by, I think it was MGM, who both claimed ownership of the, in this case, it was a copyright. But they were, and then they finally sort of got together and stopped doing that. I think I'm guessing they must have thought they were cannibalizing each other or something like that. Um, so I guess it would be a negotiation then between the personal representative and the company. Although I could imagine a situation where the ownership of the company is essentially in the hands of the executor, right?
Mhm.
And so is now what happens with the license. So it seems like the executor or the personal representative would be in a good position to work out something favorable, at least economically, for these, for these two groups. Would a
Yeah, if the executor is the owner of the brand as well as the controlling ownership share of the company, then in that case, there's not really a whole lot of conflict there because,
Mhm.
you're not going to, cut off your nose to spite your face. It really only becomes an issue when the people who are running the company are different from the people who have ownership of the brand. And that's the point where you have a potential for conflict where you might have one side or the other not wanting to associate with the other anymore.
Right.
And then you have the issue of how do we work this brand, and do we have to rebrand?
Right, right. I could imagine from the personal representative standpoint, the challenge would be creating a license agreement that allowed the company to continue using it, but one that fairly valued the value of the trademark, so that the trademark owners are getting compensated appropriately, while at the same time the company is continued to allow to use it, but also is not so unduly burdened by the cost of the license that it can't operate properly, right? That seems to me to be, a situation where you're going to have to bring in some, professionals who very deeply understand the value of trademarks and all of that to,
Yeah, carefully drafted contract where, yeah, like you said, it's mutually beneficial, and the trademark owner gets some sort of compensation or something to let them continue using the trademark, but at the same time get some control so they don't feel like they've given it away, and they don't have any further control over it.
Right, right. I'm kind of thinking this out loud, that I think if that were me, I'd work something out, and then even if I didn't have to authority wise, I think I'd probably submit it to the probate court for the probate court's blessing, to make sure that it didn't all explode when the probate closed. Right? So, because so often, everything seems great, and then, people change their minds. So give them a chance to object in court before it becomes.
Yeah, that's the way it typically works in probate, is pretty much everything. You have to notify all the beneficiaries. This is what's happening. This is what we're doing. This is what we're proposing. And, they always give them a chance to object. So, the court can't say, well, wait a minute, whatever. And as long as nobody objects and it seems like everybody's on board, most of the time the court will go with it.
Mm-hmm. So shifting gears a little bit here, a couple of times you've mentioned, well, if somebody kind of raises their hand and says, I want this. So talk about that prospect as a potential way for dealing with, ownership of intellectual property. What do you mean by that, and how might something like that work?
Yeah, so we'll talk about copyright specifically, because that's the one where most typically ownership is shared between the various beneficiaries. So if that's not the outcome that people want, if let's say you have 4 kids, and so, 3 of the kids could care less, and one of them's like, oh, I really want to keep mom's whatever alive, I don't know how to keep her book going, then what would most likely happen is, again, you got to get a valuation, because everybody's supposed to get equal shares. So if they were not specifically given that copyright, then that copyright needs to be factored into the value of their share to make sure that everyone comes out equal. And then they'd just be getting less cash in exchange for ownership of the copyright.
Oh, okay. So it's kind of like a negotiation between the heirs and how the various assets are split up, and okay.
Yeah, and usually it's up to the executor or the trustee to decide how things get split, as long as the value at the end of the day is equal between everybody. But yeah, they'll take into consideration if somebody says, oh, yes, I really want the copyrights, or hey, I really want mom's coffee table, or what have you. If somebody says that they really want something, and nobody else objects to it, then yeah, they'll factor that in and include that in their share, and just make sure that it all evens out at the end.
Mm-hmm. Okay, that certainly makes sense, and that may very well be a good solution to avoid multiple people owning something, and the difficulty of coming to terms with what's going to happen with it. So
yeah, I've had that occasion where you have, I don't know, 6, we'll say, people co-owning a copyright, and one of them really wants to pursue it, and 4 of them don't care. And then you have let's see, what is that? So that's 5. So yeah, and one person saying, oh no, I don't want this to be published, I don't want you to do this. And then you have a real sticky situation, which is why it's better to just explicitly state in the estate plan documents what happens to that copyright, so you don't have that question.
Yeah. I'm not directly involved in this situation, and it doesn't involve IP, but I think it's instructive of what happens. There's a situation where there are 3 or 4 siblings. I forget it. I think it's 3, but there may be 4. Parents died, left behind a house. there wasn't agreement on to sell the house, and so they continue to own the house, but one of the siblings ends up with all the work looking after the house, seeing it's rented out, all that kind of stuff. And the other siblings, they get a cut of the rent, an equal cut of the rent, right? But it's the burden only falls on one of them. And from talking to the fellow who is the one who has to do all the work, I mean, it's maddening sometimes because they make demands about how things will be handled, and it doesn't affect them hardly at all, but it takes them a tremendous amount of time and effort to get them done. I can imagine the same thing can happen with shared ownership of a copyright or other.
Mm-hmm. Yeah. It's, co-ownership can cause a lot of problems if people are not on the same page. So, yeah, I would not really recommend deliberately getting into a co-ownership arrangement unless, you know the person very well and you know that you're on the same page and you can move forward together.
Now, when there's a situation where there isn't professional management involved, um, what have you seen, if anything, about one of the beneficiaries maybe getting compensated for managing the IP on behalf of all the beneficiaries, so they're
Mhm.
not stuck in this situation where they're having to do all the work, but they only get their pro rata share of the income.
Yeah, and that's something that could absolutely happen. Again, you got to make sure people are on the same page. But you can say, "Hey, there's six of us, and that's too many cooks in the kitchen. Let's all vote, and this one person's going to be the one in charge," and that can work. So yeah, that's another way to get around that problem. Is don't give up your ownership share, perhaps, but agree on who's the one who's going to be in charge and how is that going to work.
Right, and then maybe that person would get compensated for the work involved.
Yeah, and that's only fair.
Yeah, yeah, I would think so. I would think so. Um, you mentioned professionals. Assuming that the original IP developer, didn't have an agent or a manager, and there's no one with the expertise to do that, where might an executor or personal representative go to, and let's say the personal representative didn't have the expertise, which would be
Mhm.
unusual if they did. Where would they go to find someone who could help with this situation? I know I'm here in LA, I could probably throw a stone and hit four people, right? But most people are not in a city like Los Angeles, right, where there's a lot of that around.
Yeah. Unfortunately, I can't really give a solid answer for that because, like you said, it depends a lot on geography. It depends on what the IP is. Even when you're the creator, finding a good agent or a good manager is tough. So I can't really recommend any particular avenue or resource for people to go to. Just that is an option, is they can try to find one. But yeah, that finding someone who, first of all, is good, and second of all, who is willing to take this on, that is going to be very difficult if there's not somebody there already.
Mm, mm. Yeah, wow. I mean, and I could imagine if if someone is a personal representative, they don't have the ability to manage the IP, and yet finding someone who can is difficult. It really puts the estate in a bind because this IP could lose its value, like you said, kind of dissipating through
Hmm.
lack of use. And what's going to happen is the personal representative going to be held liable, if you will, for that loss of value.
I mean, it kind of depends on how much value you're talking. If it's not particularly valuable to begin with, then I don't think anybody's going to really say much of anything. Whereas, to take another celebrity example, Elvis Presley was worth 10 million at the time of his death, and 7 million went to the IRS because estate taxes were done differently back then. which is another reason to do planning. But within 2 years, that 3 million had gone down to 1 million. And that was the point where the court said something is very, very wrong here. And the court actually took it upon itself to hire an investigator to look into what was going on, because, Elvis Presley's estate, that should not have been something where the assets were dwindling.
Right.
And that was how they found out that Elvis's manager, Elvis got 22 cents on the dollar, and the manager had set things up so that he got everything else during Elvis's career. And he kept that system going. He convinced Elvis's father, who was the personal representative, to keep him as the manager. And so it wasn't until the investigator came in that he said, this is egregious. This is way outside of industry standards. And not to mention, he's obviously doing a bad job here. He has to go.
Right.
And
it was the infamous Colonel, right?
Yeah. And so I don't think that the personal representative got in trouble, but the manager did get fired. And it wasn't until then that the Elvis estate really got cooking and became the behemoth that it is now.
Mm-hmm. That's so. I had no idea. First of all, I had no idea he paid so much in estate taxes, which, even granting that they were much higher back then, still 70% of your estate. Wow.
Mm-hmm.
I mean, that even now, it's, if you end up paying estate taxes, it's only 40% above the exemption.
Mm-hmm.
But wow, and then to diminish down to $1 million, it's kind of amazing that someone was able to turn that around.
Yeah, which again underscores why having the right manager is so critical.
Yeah. I mean, with Elvis, we're talking music, movies, and just the Elvis Presley name. I think would have been had trademark value of some kind.
Yeah, I heard the IRS still feels that they got gypped because they didn't consider the right of publicity value when they estimated the estate taxes.
Oh my gosh, that would have wiped out the rest of the value of the estate.
It's entirely possible, but they didn't think of it, so they didn't get it. And apparently they felt sore about it for a while after that.
Okay. I think the lesson we're doing is like don't be famous. I'm not sure.
I think the lesson is get your ducks in a row.
Right. Exactly. Well, we're coming up on our time limit, and so this is the time that I always give the shameless plug for my guest, because I know they will not do it. But it was a perfect segue, Kelley, because if you do have intellectual property, that you own and work on, so you need to have an estate planning lawyer like Kelley who understands these issues, because as you can see, and I, like I mentioned earlier, I've been dealing with intellectual property, well, for a long time, probably longer than Kelley's been alive. She's so young. And there were aspects of it that were not on my radar, and I deal in trusts and probates and estates, all the time. So, Kelley mentioned early on, if it's not in trust, again, if you have any kind of significant intellectual property, you probably need to talk to somebody who could potentially create a trust for you. You can avoid lots and lots of problems by having your property, your estate in a trust, as opposed to having to go through probate. You noticed a lot of the discussion focused on what would happen if the person died intestate. That's so often where a lot of the biggest problems come. So I invite you, I encourage you to contact Kelley. Her contact information will be in the show notes, so you can get a hold of her, and I'm sure she'd be happy to work with you to make sure that not only is your estate properly planned, but your legacy is maintained in the way that you want it to be maintained. So often we talk about fights that happen between children. Oftentimes there's a reason why those fights happen, and it's because parents have not made their wishes clear. And so it leaves open the opportunity for children to fight. And if properly drawn up estate plan has typically been socialized with the potential beneficiaries as well, so that they understand what needs to happen once, as Shakespeare said, you shuffle off this mortal coil. So, and you won't find anybody better than Kelley, especially when it comes to the intellectual property side of estate planning. So, any final thoughts, Kelley, before we sign off? Or
I think we covered all the big ones. Just one more thing to think about. If you're passing on a large amount of money, you might want to think about educating your beneficiaries so that they use it wisely.
Indeed, whether the money is coming from IP or is just coming from whatever source. Absolutely.
Yeah. To continue the Elvis Presley example, Lisa Marie Presley, about 2005, sold 85% of her ownership interest in the estate for $115 million, which again shows how things go when you have a good manager.
Yeah.
And within
Wow.
10 years, that money was gone. And I haven't followed up since her passing, but I think I might have heard that she might have had more debts than assets at the time of her death.
Wow. Shocking.
Yeah, I saw her divorce proceedings shortly before she died showed she spent $90,000 a month. This kind of boggles the mind, but yeah, going back to my point, if you're giving a child a lot of money, make sure that they know how to manage money properly.
Absolutely. Well, a great last thought to have. So I'm going to have you hang tight, Kelley, for just a minute while I sign off, and then we can talk offline for a moment. So, folks, thank you so much for joining us today. I know I see a number of live viewers. That's obviously a testament to Kelley, because there's more today than usual. So it's not to see this mug, but thank you for joining us. And if you have any comments, questions, criticisms, all the social media links will be in the show notes. Feel free to drop those in there. Tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. And my topic is the Battle of Palo Alto. And you may be saying to yourself, I have no idea what that is. That was the precipitating battle to the Mexican-American War in the sort of early to mid 1800s. And so we're going to look at what business lessons can be learned from how that battle played out. And then on Wednesday at 10 a.m. Pacific time is my show, People Making Money. And we're going to talk about invest with caution. This is a guide for dealing with a tumultuous market, which is something we've seen here for the last few weeks. I talk to a lot of people and they're like, I don't know what to do. So I'm not going to tell you what to do, but I'm going to give you some thoughts on how you might approach things for now. And then on Thursday at 5 p.m. Pacific time is my every other week show, Jiggers' Place. We're getting toward the end of the week at that point. We're going to have a cocktail and we're going to talk about duty, right? What is our duty to ourselves, our families, to society, our country? I was having a conversation with someone a couple of weeks ago now, and I was talking about I have a duty to do this and that, and they looked at me like I was from another planet. So I think it's time we re-engage with this issue, and we're going to have I don't think most people would consider this a cocktail, but we're going to have some grog, which is what the Navy always served out. And being an old sailor myself, I always associate the Navy with duty. So that'll be Thursday at 5 p.m. Pacific time at Jiggers' Place. I hope you'll join me. So, and then of course, a week from today, we'll be back for the next edition of Trusts and Estates Weekly. My guest will be Andrew Nutt Brown. He is an estate planning attorney here in Los Angeles, and he's going to talk about cross-border estate issues. So this is another sort of case of first impression, to use a legal term, for Trust and Estates Weekly. I really haven't covered this topic. What do you do when there are assets in an estate that aren't here in the U.S.? That can significantly complicate things. You can see Kelley is nodding her head. Yes. Looks like you've had some experience with this. So,
A little bit, yeah.
yeah. Just enough to cause brain damage. I've had a little bit of experience too, so I'm looking forward to the conversation with Andrew. So Kelley, once again, thank you so much for joining me today. Really a great conversation. Appreciate it very much. And for all of you, wishing you a wonderful rest of the day, and signing off as I always do. Marie, darling, you are my belle. Courage at all times, my friends.